Welcome once again to Lehto's Law. Here's Steve Lehto.
This video might get complicated, but actually it's a pretty simple concept. And it's interesting how the courts ruled on it. But Kelvin sent me a note and said, Steve, check out the story from the Kansas Reflector. Kansas appellate courts say marital property in divorce cases includes personal injury awards. And you might say, well, hang on a second. So you're saying a couple's married, one of them gets injured, gets an award for their injury during the marriage, and then they go to get a divorce, and that money that comes in, well, it was brought in during the marriage, so is that not a marital asset? Well, it's a little more complicated than that in this story, because what happened was a man got seriously injured, and he filed a lawsuit on his own behalf, but part of that lawsuit was filed on his wife's behalf, and that happens sometimes because the spouse can get injured in ways that flow from the injury the husband suffered in the situation where the husband gets injured and the wife's part of the lawsuit. So, for example, let's say that the wife is going to have to take care of the husband for the rest of their years. You might be able to get compensation for that in some states. So Tim Carpenter wrote the story. The Kansas Supreme Court reversed a district court by declaring that separate husband and wife annuities created to settle legal claims after a man was catastrophically injured in an explosion must be considered marital property in a divorce proceeding. Justices for the Supreme Court echoed a three-judge panel of the Kansas Court of Appeals, saying that the lower court judge made a mistake by concluding that the annuities held by an accident victim and his spouse weren't marital property. Both appellate courts said all property, including confidential cash awards and deferred payments, had to be treated as marital property when a marriage ended. So the justice wrote, we affirm the Court of Appeals and remand to the district court for it to conduct equitable division of the marital estate with both annuities considered marital property. And of course, they're going to have to figure out what the present cash value is of those things, but that's another story. The man was compensated for a traumatic brain injury he suffered in 2013 when a contractor installing an underground fiber optic cable struck a high-pressure natural gas line with a drill. Escaping gas migrated into a restaurant, which exploded and leveled the building. One person was killed and 15 people were injured. So the husband was injured, and his wife brought a claim for loss of companionship after her husband's accident because she said, I lost Aaron, the Aaron that was there before he got injured. And so they both resolved their claims in 2015 and received lump sum payments as well as separate annuities with payments until the year 2045. So in 2017, the wife filed for divorce, and a question that wasn't settled through negotiation was division of the annuities. So the wife said the annuities were awarded individually and it shouldn't be divided by the court. But the husband contended that the court should award him all or the vast majority of his wife's annuity because she was supposed to be my caretaker. And so he's saying, look, that money that was given to her partly was to take care of me. And so if she divorces me, that money should stay to take care of me like it was intended. But that's not what the court said. A district judge entered a divorce decree in 2022 and ruled the annuities were separate property. In response, the husband turned to the Court of Appeals because he wanted her annuity and not his own declared marital property. Court of Appeals concluded that both were marital property subject to division. The husband appealed to the Supreme Court and claimed the Court of Appeals relied on flawed legal analysis. Judge said that the wife, who had clearly lost before the Court of Appeals in a rarely seen turn, suddenly realized the Court of Appeals was correct to view all property as marital. So the judge said the lower court's consideration of mechanical and analytical approaches to property division in divorce cases was disapproved. We find it simpler to follow the plain text of the statutory scheme without the need for labels. If a label is required, one might term it the statutory approach, which has the added benefit of preserving the court's role in Kansas to interpret the law, not write it. And some people would say to interpret the law and not rewrite it. But Same effect. So here is the concept, okay? Husband and wife are married, and one of them buys a lotto ticket, and they strike it big, and they file for divorce. Well, guess what? You bought the lotto ticket during the marriage. The money you used to buy it was probably marital assets, and the money coming into marriage, marital assets. And so that everyone understands this concept that things acquired during the marriage are marital assets. Usually, I'm giving you an extremely general description here, okay? And so the interesting thing about this is the guy got an annuity, and appears that the wife got an annuity also. Now, whether hers was larger or not is not the point. He's saying, in essence, I want what I got, but I also want what she got, because what she got was, he says, compensation for her to take care of me. And it's an interesting argument. But two things, one of which is, number one, it's a marital asset. It came in during the marriage, right? Marital asset. But number two, was it really earmarked? Because I've seen lawsuits, and I've drafted lawsuits, where, and I don't do a lot of personal injury work, but I used to. And you list all of the things that you're claiming. And it can be all kinds of stuff. Lost wages, potential future earnings. But also the idea that you're going to need to hire someone to take care of you or pay someone to take care of you. That's an element of a lot of personal injury claims. And the interesting thing is that when people settle lawsuits, they quite often simply settle them for a dollar amount. And the understanding is that you've got all these claims you're making against us. I'm going to cut a check and hand it to you in full satisfaction of all your claims, all your damages, everything. This is a check that takes care of this universal issue over here. Everything. It takes care of everything. Okay? The question is, when she gets that chunk of money for her part of the lawsuit, and he gets his chunk for his part of the lawsuit, I'm curious to know, did that check actually say on it, or did the settlement agreement on it say, we're giving you this money, and this portion of it is specifically to take care of your husband? Because I bet it didn't. And I've read hundreds and hundreds and hundreds of releases. And releases are what people sign to settle a lawsuit. They release their claims through a release. Plaintiff files a lawsuit, defendant defends it, they settle the case, the defendant drafts a release that the plaintiff signs in exchange for receiving some money, okay? Most releases simply say, and trust me, it's 20 pages, but they simply say, in exchange for this money, where we deny everything and admit nothing, you are agreeing to dismiss all your claims against us, and for any damages you may or may not have, including, and they gave the laundry list of everything that's possible, whether it was in your lawsuit or not. And usually it's a check, and it just simply says, check, settlement. Settling this case. That's it. So it's an interesting question, the way the guy put it, but the fact that he's trying to get hers declared to be dealt with differently is an interesting situation, because that's not normally what they see. Normally what they see is somebody who got something during the marriage and says, but it shouldn't be considered marital property. And, for instance, the wife's family gives her a gift during the marriage, that kind of thing. And that's going to depend on the state. I'm never going to wade into that. I've mentioned before, I don't do divorce law. Divorce law, the concept of it, gives me the willies, because I've known many attorneys who handle divorce law. I know some who enjoy it. Somebody out there for everything, right? And think about a field of litigation where you as an attorney represent your client, and both sides, I'm talking about the parties, not the attorneys, both sides often hate each other. And now don't get me wrong, I've had clients who bought a vehicle and hate the manufacturer. Manufacturer doesn't hate them. Manufacturer's just, we built a bad car. What do you want to do about it? Let's settle the case, or let's settle for something reasonable. And we fight over what's reasonable. But I've seen, and I've talked before about cases where, the attorneys are constantly being fired because they can't get along with their clients. Judges have to recuse themselves, where the docketing sheet is like 20 pages long because they're constantly filing motions and counter motions, and then appealing all these interlocutory appeals. And that happens in divorce much more than it happens in general litigation. So I don't even like to think about divorce cases. I don't talk about them very often here, but this is a very interesting result. And again, this is from Kansas. So Kelvin, thanks for sending that. It's from the Kansas Reflector, and Tim Carpenter wrote it. Kansas appellate courts, including the Supreme Court, say that marital property in divorce cases does include personal injury awards received during the marriage. Questions or comments, put them below this. Talk to you later. Bye-bye.
Thank you for watching Lehto's Law. 2 most important days of your life: the day you were born and the day you realize why.